Good morning, everyone from the Pacific Northwest, and good afternoon to everyone who's on the East Coast and to everyone in between. I'm very excited to be here today to launch this discussion. And my name is Lisa Kelly. I'm the moderator. I'm at the University of Washington School of Law. And I'd ask you all to mute yourselves as we're going forward. Today we have a really exciting panel. We have Professor Addie Rolnick from UNLV Boyd School of Law. She's currently visiting at the University of Washington School of Law. Her research explores the relationship between sovereign power and the construction of socially subordinated status, examining how sovereignty can both protect and oppress. Much of her work focuses on encounters between Native youth and government systems. We also have Lauren Van Shelfgaard, who is the director of the Tribal Legal Development Clinic at the UCLA School of Law. We have with us as well Frank Edwards, who is an assistant professor of criminal justice at Rutgers University in Newark. His work explores the causes and consequences of the social distribution of state violence through quantitative research on family separation and police violence. Also with us is Brett Lee Shelton, a staff attorney with the Native American Rights Fund. Finally, last but not least, we have Teresa Rocha Berdal, an assistant professor of sociology, criminology, and American Indian studies at Virginia Tech. Her work examines how systems of law and legal actors enforce various modes of state violence and against minoritized communities. As we go forward and before we begin, I would like to offer this land acknowledgement. We want to recognize and thank the indigenous and traditional caretakers of the land upon which we all work. And with this, we have so many different tribes to be grateful to and for. Columbia University, that's hosting this symposium, sits on the ancestral and traditional homeland of the Lenape and Wappinger people. Brett is calling in from Boulder County, Colorado, the traditional lands of the Arapaho, Ute, and Cheyenne peoples. Lauren is calling from Burbank, California, which is the traditional lands of the Gabrielino, Tongva, and the Fernandino, Tataraviam, and Chumash peoples. Addie and I both are calling from the Coast Salish land here in Seattle, Washington. She normally works in the Nuwuvi or Southern Paiute territory in Las Vegas, Nevada. Teresa is calling in from the Haudenosaunee homelands in Syracuse, New York. Frank is calling in from the Muncie and Paiute regions in New Jersey. We acknowledge that simply acknowledging the original inhabitants and their continuing vitality is, of course, only a basic first step. As a collective, we each work to actualize our acknowledgement by offering direct service to tribal nations in the areas of legal advocacy, nation building, and research. We encourage everyone here to consider how you are choosing to live out your land acknowledgement statements in ways that center the voices, needs, and futures of Native peoples. What we hope to do today is sort of deviate from the usual panel discussion of each person putting forth their paper and instead have a sort of interactive and interwoven conversation. Lauren is going to kick us off with a discussion of how all of these papers thread together. And from there, we will move to questions that each panelist or the panelists will in turn comment on. At the end, we'll have a Q&A, and we're looking forward to your questions. Please feel free as they come up for you to send to me in the chat, just individually to me, Lisa Kelly, your questions so that I can gather them. And when it's time for the Q&A, I can attempt to sort of shepherd them through the time that we have left for Q&A. One last thing, rather than a separate breakout room after we are finished with our time, we're all just going to remain in this room. We feel like our papers are much too intertwined to separate us out. So if you're interested in staying, please do, and you can ask any additional questions. Thank you. And with that, I'm going to turn it over to Lauren.
Thank you, Lisa. Greetings, Guatsi. Thank you all for joining us. Sincere gratitude to the conference organizers, the Columbia Journal of Race and Law, all of the brilliant article contributors, as well as thank you to the starting premise that the child welfare system, as it is, should be abolished and that child welfare should be re-envisioned. As a panel, we are especially delighted to see space made to specifically address the impacts of the child welfare system on the well-being of Indigenous families. We had the opportunity to gather ahead of time to discuss the overarching themes of our work and how we wanted to approach this panel. In doing so, we collectively determined that the proposed title session for this, the quote, distinctive Native American experience, was not entirely accurate. Rather, it is in fact the inverse of the session that we want to have today. Far from being distinctive, the Indigenous child welfare experience is not just emblematic of the current child welfare and the reasons abolition is necessary, it is the child welfare system. As we detail in our papers and what we aim to discuss today, the child welfare system operates, makes assumptions, and fails in the ways that it does because it is the direct outgrowth of the assimilationist policies originally engineered to fix the Indian problem. Harms to Indigenous families are not just an unfortunate byproduct or a disproportionate impact. Rather, the federal government explicitly sought to wholly separate Indigenous children from their parents, their families, their communities, and their cultures, and replace those connections with Americanization. The explicit goal was removal. This goal has morphed, but the structural beams of this institutionalized system remain. They inform the assumptions and the decisions for all subsequent child welfare development. Why does the system seem geared towards providing babies to adoptive parents more than preserving families? Why is extended family and community not more heavily considered in placements? Why do outsiders make inquiries? And why is the expression of their authority adversarial and punitive? To justly question why abolition should be considered and how we might re-envision child well-being, we are compelled to inquire as to the origins and motivations for this system. That leads us directly to Indian country. Because the child welfare system is a direct descendant of the federal assimilationist policies aimed towards tribes, it is also true that tribes offer us some guidance, especially as resistors when we reimagine child well-being. The reemergence of traditional systems offer insight, including into the parent-child legal relationship, the role of community, and the process of healing. We therefore propose to rename this session Lessons from Indian Country on the Origins of Child Welfare and Reimagining of Alternative Futures. We are really grateful to be part of this discussion. And I think with that, we will dive into 4 questions posed to all of the panelists. Lisa?
Yes. So our first question is, and Frank, you might want to move to the next slide. There we go. What is the origin story of child welfare's family separation underpinnings? And for this, we're going to turn first to Addie.
Thank you. So Frank, you can leave the slide here for a minute. I'll tell you when to change. So everyone participating in this conference, I think it's safe to say, agrees that the modern child welfare system doesn't help children, but I have heard different terms when I was listening to the session yesterday, slightly different terms that speakers have used to describe the problem. So did the child welfare system work for a while and stop working at some point in history? Is it a system that is supposed to care for children but has somehow gone wrong? And so I want to make clear some of what Lauren was saying, but I want to make clear that the starting point of our panel is that the child welfare system was not ever built to help children at all. It was created to destroy them and to destroy them by destroying families. More specifically, it was created to tear families apart in order to control problem populations. So the rhetoric of helping children is a rationalization that comes after. It's a rationalization for that purpose. And some system actors undoubtedly believe in that rationalization. They think they are helping children, but believing in that doesn't change the fact that the system has always operated to hurt children and to tear families apart. So the fact that it continues to do so today isn't new and shouldn't be a surprise. And this purpose can be seen most clearly, we think, by tracing the history of Native children's involvement in the system. So governmental intervention in the lives of Native children and families was explicitly premised, as Lauren said, on forcibly assimilating children by severing ties between the child, family, and the community. Teresa will say more about the legal structure that enabled this in more detail, but it was done as a way for American policymakers to solve what was called the Indian problem, which is the continued presence of indigenous nations standing in the way of American expansion. So Colonel Richard Pratt, who was the architect of the government's policy toward Native children in the boarding schools, explained that instead of physically exterminating Native people, the government could instead, quote, kill the Indian in him in order to save the man, starting with children by re-educating them in schools. So the boarding schools that first brought Native children under state control were one piece of a larger campaign to destroy Native nations via assimilation of individual people. So we think it's important to look at the experience of Native children because of the explicitness of this goal. Can you go to the next slide, please? So focusing on Native children also shows us that the modern child welfare system is connected to several other systems that we think about as unrelated or separate, including the juvenile justice system, the criminal system, and the education system. All of these are, I think, better thought of as formal systems of state control over children that started to crystallize in the mid to late 1800s. All kinds of children were under state control at that time, but they were not all in the same systems. So the early child welfare and juvenile systems served mainly white immigrant children. Many Black children at that time were in the adult criminal justice system, and Native children were in these federally run boarding schools. Academic histories that focus on a specific system can miss the interrelated history of all of these systems, and it may explain why histories of child welfare don't always begin with the experience of Native children, because they were formerly in a school and not in state child welfare systems at that time. But in fact, the boundaries were and still are porous. So I'm going to go through a few slides quickly with pictures, because I think the best way to illustrate the porousness of the systems is by showing you some of the buildings and telling you about the people. Next slide, please. So this is a slide from the Carlisle Indian School, which is the first Indian boarding school founded by Colonel Pratt in the late 1800s. And Teresa will tell you a little bit more about Pratt's philosophy and the Carlisle School. Colonel Pratt, you might be interested to know, next slide, please, started worked originally at Fort Marion, which is a prisoner camp in Florida. So some of the first Carlisle students were Apache prisoners of war who had been brought with their parents, who had been captured for resisting US expansion, to Fort Marion in Florida. Captain Pratt used to work there. He had honed his assimilation curriculum at the prison camp with adults, used it as a blueprint to open the Carlisle School, and then went down and imported his first class of children from the Florida prisons to test the model. The children's parents were then transferred to Fort Sill in Oklahoma, and the children were in Pennsylvania at Carlisle. Next slide, please. So Carlisle is a museum now, but many of the boarding schools still operate. This is Chemawa Boarding School in Oregon. It's the oldest continually operating boarding school. This is a picture from 1937 of girls being trained there. So many of you might have heard of the 215 unmarked children's graves that were discovered at the Kamloops Boarding School in British Columbia. You may not be as familiar with the fact that unmarked graves of children are still being mapped out right now at Chemawa. Many of them are the graves of the children who were made to construct the school. All the children who were there, whether they built the school or not, were trained into these these versions of whiteness through the school's curriculum. So Chemawa is still open, but today it's run by the Bureau of Indian Education, and the Bureau has kind of rejected its past assimilation policy and runs it now with the goal of providing a positive educational experience for Native children and supporting tribal self-determination. Next slide, please. So you might be surprised to know that in 2003, a girl named Cindy Gilbert So Happy died at Chemawa. She was a student there. She died because she was locked in a cell that the school uses as a drunk tank for kids who get in trouble. Nobody monitored her. They didn't monitor her closely enough, and she died while she was locked in the cell. So I imagine many of the people in the audience graduated from boarding schools as well, and you're probably thinking, boarding schools don't usually have drunk tanks, because they don't. You might wonder why there were cells at this school. Next slide, please. So this is a different kind of building. This is a state-run building. This is Aurora Plains Academy, which is a residential treatment center in South Dakota's juvenile system. Next slide, please. Before it was Aurora Plains, it was called Plankinton School for Girls. It was a boot camp and a state incarceration facility before that. Native children make up a huge portion of South Dakota's juvenile system, and they're subjected to a sort of a get tough curriculum and kind of brutal practices at Plankinton. They used 4-point restraints and riot gear to tackle the children. Those practices only came to light after Gina Score, this girl, died from being forced to run in hot weather. So like Chemawa, the building has been rebranded. It's now a treatment center run by a private company, but the abuse complaints there actually haven't stopped. So the point I want to make by showing you these buildings and telling you about the people is, if it's not clear to you which of these is a school, which is a prison, which is a treatment center, and which is a predecessor of the modern foster care system, that is because there is no functional difference between those things for Native children, and there never has been. Federal and state government intervention took many forms, but it was always done with the goal of assimilation, and that goal was always accomplished through child removal, confinement, and discipline. Go ahead, Teresa.
Great, that was awesome. I love that you included those images. So to illustrate our collective argument that even the most radical reform efforts are limited when the dominant system remains intact, we want to take a moment to kind of briefly describe some of the violence of early US policy. As Addie's paper explains, and which the images that she just showed are connected, the state has long-standing carceral commitments to surveillance, containment, and coercive control of not only Native lands, but also our families and resources. And we suggest that these commitments have subtler colonial logics of elimination embedded within them that reveal the state's continued desire to physically and culturally eradicate. And there are 3 congressional interventions that Frank and I use kind of as the framing, the early framing in our research paper. And these interventions in the 1800s really illustrate these settler logics. And first is the Civilization Fund Act of 1819. So what this act did was it sought to, quote, civilize Native peoples by providing educational instruction. So kind of laying the foundation for what Addie just described. What the act ultimately did was formalize congressional support of Christian missionaries who were already working and proselytizing among the tribes. Together, Congress and the missionaries sought to assimilate tribal members into European culture by removing tribal identities and worldviews. Colonial paternalism of this kind eventually promoted the construction of off-reservation boarding.
Let's go.
Additional boarding schools where children
We're going to end up with a curfew at night for you to not be on your phone anymore.
Where children could be further alienated from their tribal homes. Second is the Indian Removal Act of 1830, which provided then President Andrew Jackson with unrestrained authority to seize Native lands, relocate tribal communities west of the Mississippi River, and then redistribute this desirable territory to white settlers. So in our work, Frank and I suggest that separating Native peoples from their lands through the Indian Removal Act and other policies was a visible, kind of tangible precursor to the continued removal of Native children from their tribes and families today. And Frank will show you a number of tables and graphs and figures later on to kind of show what that looks like. Third is the General Allotment Act of 1887, which took Native lands and transformed it into private property. The act reduced the already dwindling acreage of Native land by more than 2/3 by giving away millions of what the federal government deemed surplus Native lands to white homesteaders. Unsurprisingly to probably everyone on the call, white settlers were granted the best allotments. and Native peoples were often forced onto land that was unsuitable to sustain farming or livestock. But in addition to taking Native land outright, the act was meant to sever the cultural bonds that existed between tribal members and their lands and their waterways. Allotment targeted these cultural bonds by ending communal living and fracturing the kinship networks that are commonly used in child rearing, which ultimately limits the intergenerational transfer of language, traditions, cultural practices, histories, and worldviews to Native children, the very thing that makes us Indigenous. I'm gonna kick it back to Addie.
Thank you.
You can skip that slide, Frank.
So I'm just going to really briefly talk about delving a little bit more into looking at what happened when kids were at the schools. There's just 3 themes that I think are important. So the first is just the idea of assimilation, and we've talked about assimilation as a goal, but I want to say more about what assimilation meant in this context. So this is not from the schools, but as part of allotment. So at that time, Native people were not citizens, and it wasn't until 1924 that there was a collective naturalization, often against the will of people who didn't see themselves as American citizens. But before that, what happened is sort of as a trade-off for allotment. The Bureau had, so Interior had this ritual of citizenship, and people would get allotments, and then they would sort of become citizens, and they would go through this ritual in which they would give up like the men would give up their bow and arrow and take a plow, and they would give up their name and they would take a new name. So it was a very scripted ritual of sort of turning into a white person. And one of the things that I think isn't talked about as much here is that the version of assimilation that happened in the schools and happened in this this process was a very gendered version of it. So this is an excerpt of what the women said. So they got a purse, and they exchanged something else for a purse. And they said, this means that you've chosen the life of a white woman. A white woman loves her home. The family and the home are the foundation of our civilization. Upon the character and the industry of the mother and homemaker largely depends the future of the nation. So girls were taught domestic arts in the schools. Boys were taught manual labor. Boys were used to build the schools. Girls were used as servants. And this is part of the assimilationist project. So Colonel Pratt, in his work in the prisons in Florida, had developed a whole theory of assimilation as something that would be beneficial to Native people. And he also worked with Black prisoners. And he didn't believe that Black or Native people were suited for, what you might call full first-class citizenship. He believed instead that they were suited for a sort of a second-class citizenship. And so this was something that he tried to achieve through work and through rigid discipline. So this affected the way that children were trained in the schools. Schools also used something that they called an outing program, in which children were then loaned out to white families where they would work in exchange for their care. This work was considered transactional and educational for them. And a similar system was used for other children in early state juvenile systems. And Pratt had actually borrowed that concept from state reform schools who were farming out children in the same way. The second thing that I want to emphasize is this idea of separation, and where it comes up is if you read boarding school accounts from parents and from children, the most dominant theme that you hear is one of kidnapping. So that's kidnapping is the way that most people describe it. So many parents didn't want to send their children to the US schools, and federal officials would sometimes respond by rounding up children and forcibly taking them away from their parents. But even when the parents sent the children voluntarily, their accounts are still described in terms of kidnapping and forcible removal. Children were sometimes kept at the schools through summers so that they would not do what the officials called returning to the blanket. And that was the term that they used to describe children who became reacculturated in their home communities. So the last thing is that boarding schools are steeped in stories of discipline and confinement. Children at the schools were given harsh discipline, abusive practices, washing them with lye, hitting them, some kind of extracurricular abuse like sexual abuse. And then when they resisted, when they ran away, they were labeled incorrigible or troublemakers. And sometimes they were disciplined in the schools, other times they were sent to state reform schools. I just want to show you one more slide. This is a letter from Christine Smith, whose granddaughter, Hannah Kennedy, was sent to Carlisle. Hannah got in trouble and she was sent to the state reform school. And Christine sent a letter saying, can I please have my granddaughter back? I need her here. It's been the 4 years that she was supposed to be here. And I don't think that they ever answered her. So what happened is they committed her jurisdiction completely to the state reform school, and the state reform school found a white woman locally who would take Hannah after her term there was done. So I don't think that she ever made it back, and I'm not sure that her grandmother was ever told what happened to her. So these themes of assimilation, removal, discipline, and confinement are also prominent themes in the story of foster care.
Okay.
So
Can I share just one thing real quick? I just had this, it's so hard to like communicate how personal the boarding school stories are for so many Indigenous families, and the discovery of the mass graves and subsequent discoveries at 2 more schools in Canada pushes for the ground penetrating radar at schools in America. It's all very, very tumultuous in Indian country right now. And so I found myself being very impacted by those pictures. And I'm sitting here in LA County, and it doesn't rain here anyways. And then the drastic drought that we're in, it definitely doesn't rain here. And just as you both were speaking, a giant rain cloud just opened up on top of my house and started pouring rain. Oh, it was just a moment. And then I just wanted to recognize that this is such a moment in Indian country, and yet it's just reflective of how so little has changed. But anyways, I was compelled to share. Water's falling from the sky.
I love that. Thank you, Lauren, because this is really hard. And I always have to take deep breaths. I like that we're switching off so I can take a deep breath and allow the emotions to settle. And just to kind of echo what Lauren said, for people who are listening on the call, especially Native relatives who are listening on the call who have personal experiences with these kind of moments and continued acts of violence. So Lisa, I will allow you to answer the next question, or to pose the next question, and then I'll start again.
Okay. Yeah. Thank you. Thank you to you both. I know, I feel like we should be having trigger warnings or something. This is a ongoing trauma. So to transition more to the law after that, what are ICWA's salient features? And I do believe we're back to Teresa.
Yeah, thank you. So what I'm going to do is just kind of give a little bit of background to the Indian Child Welfare Act, and then just discuss some of its kind of basic elements, and then I will transition to Brett, who will take it from there. So following from the first question and Addie's presentation of the kind of carceral interlocking commitments, I just want to transition us to say that in time, the settler states' commitments to the assimilation and removal of Native children in boarding schools, it's strategically transformed into things like foster care and adoption of Native children into non-Native homes. So in 1958, for example, the Bureau of Indian Affairs launched what was called the Indian Adoption Project. What did it do? It essentially took Native children from their own families and placed them into adoptive homes with white families. And money, as you might imagine, is also important to this story and to the legacy of family separation. The reason being is that the adoption project was deemed financially efficient for the state's genocidal goals, because what it was doing is it was shifting the financial costs of assimilation from the government onto the children's new adoptive families. This level of removal, though, wasn't enough for the state. And in 1968, the adoption project was incorporated into what's known as the Adoption Resource Exchange of North America, in order to place even more children outside of their homes. And if genocide is ultimately the goal here, then these adoptive efforts were disastrously successful in the years to follow. A 1976 report from the Association on American Indian Affairs found that upwards of 25 to 35% of all Native children were being placed in out-of-home care, and 85% of those kids were placed in non-Native homes, 85%. So in response to this mass removal, tribes and allies mobilized against the theft of their children. And due to their work and the data in the 1976 American Indian Affairs report, the Indian Child Welfare Act, or ICWA as we'll call it as we move along, was passed in 1978. The ICWA was implemented to end generations of abuse, mistreatment, and forced removal. Its stated intention was to protect Native families and tribes by preventing the unnecessary removal and displacement of Native kids from their homes. The ICWA also stipulated that whenever possible, Native children should be placed with extended family or foster or adoptive homes that reflect the unique values of Native culture. Unfortunately, state and federal courts were inconsistent in their interpretation and compliance with the law. The federal government responded with new regulations in 2016 to address these problems. I'm going to transition to Brett and we'll continue to expand on ICWA.
Okay, thanks, Teresa. Some of the most salient points about ICWA are how it sets out priorities in how children are to be treated and how their situation and planning will be conducted. First off, the tribes have standing. If a child may be Indian, then their tribes have standing to intervene into their case. That's a big deal because prior to that, there wouldn't be any standing for the tribes. Also, there's a placement priority established, which mirrors something that really makes a lot of sense when dealing with Native people and what we'll talk about in terms of rights of the Native children to know their culture and to know their relatives within their nation. The priorities roughly go like the first children should be placed with their family, then their extended family. And if there's nobody in the extended family, still within the tribe, who's another version of an extended family from a Native viewpoint. And then if there's no placement within the tribal nation available, then they could go with some other Native family and so on. So it establishes that priority that has to be evaluated. And so children get placed a lot closer to where they actually belonged initially under that rubric. And then another really important point is that active efforts are required in order to preserve a family. So it actually slows the rate of removal by raising the standards that have to be applied before removal is allowed and before termination. All in all, this is about human rights law. It's about recognizing Indigenous children's rights to remain connected to their family, to their relatives beyond their nuclear family, despite what may be going wrong within the nuclear family, and to their community and to their culture. That's what it all sets up with those important features. And it also recognizes a tribe's right to self-determine how its people ought to be dealt with, how they ought to be serviced, where their children could be placed, what's important within the tribal contemplation of the options available. It replaces power in the tribes and helps to reestablish, at least give a foothold for the Native children's rights. And that's a different view entirely from the historical treatment of children. So I will pass the baton back. Teresa, do you have anything, or should we move on to the next question?
We're moving to the next question so we can see this facts and figures.
Okay.
Thank you, Brett.
So how successful has ICWA been in achieving its goals? I think for this, we're looking to Frank.
Thank you so much for having me today. So what I'm going to do is I'm going to present you all with a series of data visuals that look at the data that others have mentioned that the Association on American Indian Affairs compiled as part of their research to support the initial passage of ICWA. And then we're going to look at contemporary administrative data to think about levels at which American Indian and Alaska Native children are placed into foster care and adoption today. And I want to emphasize this is not an exact analysis of the efficacy of ICWA in achieving its stated goals, but what we're going to speak to is the ongoing crisis of family separation in Indian country. So first, let's look at the number of children, of Native children who are in foster care, according to the Association on American Indian Affairs as of 1976. And these numbers were digitized from the congressional testimony. So we can see states like South Dakota, Minnesota, Arizona, Wisconsin, Washington had incredibly high numbers of Native children in foster care in 1976. When we compare those to contemporary numbers, and these are 2018 numbers from the Adoption and Foster Care Analysis and Reporting System, we can see that in some states, caseloads today are in fact higher than they were in the pre-ICWA period. So for example, if we look at Oklahoma, we can see that around 300 Native children were in foster care in 1976. But as of the end of the reporting year in 2018, there were about 1,200 Native children in foster care in Oklahoma. Thinking about this as a proportional change relative to non-Native children, we can take the 1976 caseloads as a baseline and then ask whether those caseloads have grown or diminished over time. And we look here on the left panel at Native children and the right panel at non-Native children to give us a sense of how these caseloads have moved for different groups. So we can see, for example, that adoption and foster care for Native children in the green bar indicates adoption, the orange bar indicates foster care. In Wisconsin, numbers of adopted Native children have decreased since 1976, but numbers of Native children in foster care have grown somewhat. When we look at Oklahoma, both the numbers of Native children in adoptive homes and in foster homes has increased dramatically since the passage of ICWA. Right, and we see some inconsistencies and differences across the state. The growth in Native caseloads in adoption and foster care in Oklahoma, when we look at non-Native children, is nowhere near as large. Right, so we have here some ways to think about whether the growth of these systems across states was particular to Native children, or whether the growth of these cases across states applied universally to all children, especially in this critical period between the 1970s and 2000s, when the system grew dramatically. Now, to help us understand the mechanisms of inequality in the ways that Native children come into the child welfare system, we compute age-specific event risks. So we think about the likelihood that a child experiences a child welfare investigation, a substantiated case, a foster care placement, or the termination of parental rights by age. The green bar indicating the rate for Native children nationally, and the orange bar indicating the rate for white children nationally. And we can see that nationally, Native children are at a slightly lower risk of investigation than white children, that they're at a slightly higher risk of substantiation than white children, a significantly higher risk of foster care than white children, and a higher risk of termination than white children. But these national averages really do mask a lot of variation across places. So when we look at the risk of investigation for children by states, and here on the Y, on the vertical axis, we have the probability of being investigated. And on the x-axis, we have age. So when we look, for example, at Minnesota, we can see that 15% of American Indian infants in Minnesota can expect to be investigated if risk levels stay where they were between 2014 and 2018. Again, that's 15% of infants, right? These numbers are incredibly high. When we look at Alaska, the rate's even higher, right? It's about 16% of infants in Alaska. Native infants can expect to be investigated before their first birthday, right? So this is, 1 in 8 in those places, and that's just investigations. When we average these to lifetime risks, so we run a simulation that hypothetically exposes these children to risks over time. We see that in Alaska, for example, 4 in 5 Native children can expect to be investigated by their 18th birthday. In Minnesota, that risk is about 3 in 5. Right, so about 80% of Native children in Alaska can expect an investigation before they turn 18. About 60% of Native children in Minnesota, Nebraska, Oklahoma can expect an investigation before age 18. And that number is above 50% in many states. So this is a normal event in the life course of Native children. Here I provide a similar map, but looking specifically at foster care. And in Minnesota, again, 1 in 3 Native children can expect to be placed in foster care before their 18th birthday. 1 in 3 will ever be placed into foster care. This is extraordinarily high, and there's a large number of states where it's more than 1 in 5 children, more than 1 in 5 Native children will ever go into foster care. Incredibly common. And when we look at the rate ratio, that is what we often describe as disproportionality, or the ratio at which Native children experience these events relative to the rate at which white children experience these events, we see really clear patterns of inequality. Clusters of states in the Midwest and Northwest have relatively high levels of inequality. For example, when we look at foster care for Minnesota, the risk for Native children going into foster care relative to the risk of white children going into foster care is more than 10 to 1. In the Dakotas, that risk is over 5 to 1. These inequalities are profound and exceptional, but we should also note that in Minnesota, Black children also face an exceptional inequality in the likelihood of going into foster care. In Minnesota, the risk is about 9 to 1 for Black children relative to white children, right? So these inequalities cluster at the state level across places, but we see a really clear geography in terms of which states are driving these incredible levels of inequality that we see. Now, lastly, we look at trying to understand what some of the sites of these inequality may be, right? So for example, when we looked at our maps of investigations, one place that inequality can emerge in the child welfare system is through the front door. That is mandated reporting and investigations. And we saw that, for example, in Alaska, 80% of Native children will ever have an investigation. So the front door has been thrown wide open in many states, including Minnesota, including Alaska. But we want to think about out-of-home placement, perhaps, as the thing that we're most interested in understanding and most interested in reducing, or termination of parental rights. And so we think about where these inequalities may emerge, and we condition those probabilities of investigation on other events, or rather we condition the probability of later events on earlier events. So for example, when we nationally, we condition the probability of substantiation by a child having already been investigated, we can see that Native children, when they have an investigation, are more likely than white children to be substantiated, right? So here we can effectively say that about 40% of Native children can expect to be substantiated post-investigation, and that rate is about 5 points higher than the rate for white children. Now, after investigation, we see a large gap. So Native children who are investigated, infants, right, we're looking over time, so about 1 in 4 infants, Native infants that's investigated is likely to be placed into foster care, compared to about 12% of white infants, right? So we have about a double of the risk of foster care placement for Native infants relative to white infants post-investigation. The gap is even larger post-substantiation. That is, nationally, Native children are at much higher risk of being placed into foster care after a substantiated case than are white children, right? White children have less than a 50% risk of being placed post-substantiation nationally. The risk for Native children is over 60%. We see similar rates of termination after foster care placement nationally. And when we look at the state level, of course, these conditional probabilities do vary quite a lot. So for example, here is the probability of foster care conditional on investigation. We can see a tremendous gap in Minnesota, right? So not only is the front door wide open in Minnesota in terms of the number of investigations coming in, but when Native children are investigated in Minnesota, they are dramatically more likely to go into foster care than are their white peers at all ages, right? So looking across horizontally, we're looking at risk over across ages. And you can see that there's about a 15 to 20 point gap in the probability of Native child being placed into foster care in Minnesota after an investigation. In Oklahoma, the gap is much narrower, right? And so this might suggest to us sites at which particular kinds of interventions are appropriate for different mechanisms of inequality across systems. And so just to briefly summarize the quantitative findings, and if you're interested in these, we have a detailed report that goes through these findings in much more detail. But in many states, there are more American Indian and Alaska Native children in foster care today than there were in 1976. So despite the critical protections of the ICWA, the crisis of Indian family separation is not over. American Indian and Alaska Native children are more likely than any other group to ever be in foster care. And nationally, there are large inequalities at the placement decision stage. The decision to place a child into foster care is one of the key places where Native children are exposed to high levels of inequality. But in a handful of states, the front door, that is those screened in cases, those front doors are tremendous. And there are incredible volumes of Native children being investigated by child welfare systems. And we also see large numbers of Native children, especially older children, placed in non-kin or non-Native settings. Brett mentioned the placement preferences for ICWA. We don't detail this. I didn't show you the slide here, but in the paper, we describe rates at which children are placed with kin or with other Native families. And we find that for the states that have high caseloads, at no age are more than half of Native children being placed with kin or with other Native families. So it suggests that there's quite a long way to go for compliance in state CPS systems for placement preferences, bringing them in line with the requirements of the ICWA. So I apologize, I don't know who's next, but.
Yeah, although that's a cute little Addie baby, I think. So why has ICWA not moved the needle, especially in places like Minnesota? You know, I think there's a couple things there. To reiterate what Brett had said earlier, ICWA is a human rights law. It was a game changer. It is a dramatic clapback against the status quo of the child welfare system. And yet it seems to have changed very little in the overall child welfare system. Even within states that have domesticated ICWA into state law, there is still just mountains of litigation in which courts are doing everything they can to avoid having to comply with ICWA. That's where all of the battles are. Please don't make us comply with ICWA. No, this child is an Indian. No, they're not a member. Just constant. You think there would just be this default, well, we're not sure if ICWA's going to apply. We're just going to assume it does. That's not what's happening. And it's kind of bizarre because even though ICWA is specifically designed to address the ills targeted against Native children, the actions within ICWA are not all that unique to Indigenous communities. It's saying that the local community should be a stakeholder and that children have a right to continue to be family members of their community. That seems pretty basic to me, and yet it is not permeated child welfare at all. So it's just not being complied with, even in states that are trying to make active efforts to do so. But it's also true that even if ICWA does apply and the tribe gets to be a stakeholder, even transfer the case into tribal court, what happens once the case is in tribal court? Tribes are sovereign nations. They're free to design their child welfare system however they want to. But it's also true that they operate in the real world, which includes very heavy pressure of federal Indian law on how tribes can and should operate, at least according to the federal government. Like other child welfare systems, money is everything. Tribes were apparently, obviously, an afterthought when it came to the child welfare funding in the Social Security Act, namely Titles 4B and E, but tribes are eligible. And in fact, that's where they get 90% of their child welfare funding, in part because tribes are effectively barred from having a tax base and have no other way of producing that money. And so tribes, despite ICWA, are mandated to construct a child welfare system that looks, feels, smells, and sounds just like the state one that they transferred the case from. We have all the same ills of the state child welfare system being mirrored in the tribal one. For us, that includes things like this approach to the parent-child relationship as an isolated system in which parents exclusively hold property-like title over their children, which the court can then terminate permanently, absorb that title, and then transfer it full, free and clear to an adoptive parent. It includes little to no recognition of the community of extended family, the support or the stake that they can and should have. And it also treats all of these rights like property rights that the parent has. Even though we use verbiage like the best interest of the child, we really mean, do the parents deserve to hold on to these rights? We look a little bit into the funding pressures on tribes, make calls for it. This is a huge mountain that has to be approached when we're talking about abolitionist work. Tribes, I think, are actively resisting, are attempting to be creative within the confines that they have. So it's not for a lack of trying. We see really interesting examples from things like customary adoption. Numerous tribes have wholesale rejected the notion that parental rights can ever be terminated and have instead turned to customary adoption or permanent guardianship as alternatives for placement. Nevertheless, Title 4E is this monster looming in the back, putting extensive pressures on tribes, really nullifying ICWA and the immense work that it's attempting to hold the line against the pressures of the child welfare system. Brett, did you have anything you wanted to add there?
That was really well done. Maybe just to highlight the fact that restrictions on funding are used to basically hamstring tribes and keep them from innovating as much as they're capable of. I'm kind of restating what Lauren said, but for example, the Title IV-E funding typically runs through states in order to get to tribes, and that's just necessary under the federal law. But the problem is that the states are held to standards, so that if they do pass funds through to tribes, then the states have to require that tribes do certain things. And sometimes those certain things are these exact same onerous requirements that are rooted in these old policies, basically. So tribes become basically their own jail keepers in that way. Similarly, in other programs, it's really tough for the federal government to let go of the control via the purse strings. So the Families First Preventive Services Act was another, seen as a potential, if we can intervene with families and thereby prevent outplacement of children, how great would that be? But in order for tribes to do that, it's really tough, because it has to go through a state approved model for the most part. And so that it's a recurring theme tied to purse strings, and that reduces the abilities of what the tribes can do. Yet tribes as sovereigns, if they were allowed the freedom and if they had the financial resources to fully innovate, they could be little test tubes. And that's what we argue. This innovation is already going on, and the success stories are starting to be recorded. But that's in spite of the way that the system is stacked against tribes at this point, and that's in our paper. So thank you.
Okay, I think we're ready for the last question, which, oh no,
For some reason, we don't have a slide on the last
I
question.
think the last question the slide wound up being folded in somewhere earlier, but here's the last question. Abolition is both a destructive and generative movement. And so the question is, since the old system needs to be uprooted to make way for something new, and as we move towards abolition, what can we learn from what tribes are doing in the space that is provided by ICWA, despite all of these challenges and barriers that we see? And I think we were going to go to Brett and Lauren first on that, but I see your slide up so nicely there, Addie. I hate to I hate to pass it up.
It's a fine slide for Brett and Lauren as well.
Yeah, so I think I'm going to try and tee up Brett. We are very interested in what tribes are doing, and firm believers that tribes hold at least some of the ingredients for a hopeful future. There are a lot of ills, and I'm so interested in this symposium in identifying and really articulating what these ills are, because only through fully understanding, how the child welfare system fails, are we going to be able to meaningfully build a system that is in fact responsive. For us, at least only some of these failures include approaching children and parents as these isolated systems, as well as approaching the whole adversarial system, which especially in the criminal justice, but is very much mirrored in child welfare, approaches everything from rights. You have a right to be a parent until we terminate that right. And for us, that's just not a useful template when talking about families and with children. Rather, as a number of tribes have actually codified in their tribal law, children are not only sacred, but because of their sacred status, we as community members, as members of the tribe, as family members, have positive duties, obligations that we owe to these children. Parents have duties to those children. All community members have duties. And so yes, rights is a way to articulate it, but only as it's relevant in opposition to the duty owed. I have a right in relation to the duty my parents owe to me, in the same way that I have duties that I owe to my parents as well as to my children. So with that sort of inverse perspective, we're looking at, how can we start to peel back some of these failures? We need to get out of this adversarial system. This police state of intrusive nature, that is just not working unless your goal is to find a bunch of babies for adoptive parents. In that case, it's very good. We need to start to manifest, articulate, realize the active duties we owe to these children. How can we do that? We identified at least one non-adversarial promising practice that tribes are already using, a lot in dispute resolution, but some in child welfare that I'm going to turn over to Brett to better articulate.
Yeah, so I mean, tribes have dealt with these sorts of issues for millennia before they were even granted the tribal court to adjudicate adversarial issues. And so what tribes are interested in doing is looking into their traditional knowledge about how these issues were dealt with, and what they've identified, really what they've carried forward a lot of times alongside the system, and what they're starting to try to incorporate within their existing systems is a different approach to things, where you allow people who have an interest in who can contribute to a positive outcome in a situation to have a say. The standing is more inclusive, and get together and talk about stuff. So what we call that in our paper is circle processes. What it's sometimes called is peacemaking. It's also the same thing as family group decision making. There's little variations on the rules and everything, but the approach is the same. That's get the people together who have an interest and who may contribute to a solution, have them talk it out and come to a consensus about what should be done moving forward. Sounds groundbreaking if you're coming from the perspective of law school and learning how to be a warrior in the courts, but if you're a human, this stuff goes on all the time, and this is how humans resolve things. And in fact, this is how indigenous people around the world have always resolved things and continue to do so. And so that's what we highlight in our paper. And this means throwing off the adversarial process in this situation. In fact, child welfare cases are one of the first places that tribes want to employ something like peacemaking or circle processes, like we argue for, because of the potential that it offers. And as we describe in the paper, it offers much more resilient solutions and better buy-in. When you approach the problem not as the parent has done wrong and what will we do with the child because the parent no longer deserves the child, instead look at it as what the child is having things go wrong, and we have a responsibility to make sure that certain things happen for the child as they grow up to become a member of our community, a full-fledged member of our community. What can we do? And the nuclear family has had problems, and what do we need to do in order to help them is the first area, first locus of inquiry. And from there, that spins out into responsibilities by implication. The obverse of the need on the part of the child and of the nuclear family to have support from the outer community is a responsibility in the outer community to step forward with what they need, because in the end, that family and that child are a vital part of the community. And so it just flips everything on its head. It's 180 degrees worldview difference that's employed, but it's innovative. And I would argue that this sort of treatment is what all children deserve, not just Native American children who are eligible for membership in a tribe. This is something that should be looked at as something that's good for all children. We should afford this to all children. We should say who all can help take care of this child, given that they're having issues and problems. Who all can help this family? That's family preventive services there. So standards that we're advocating for on behalf of tribes can actually be leaders in a reworking of how the child welfare system can look. And just all we have to do is empower tribes on a very small scale relative to the federal system to do what they would rather do. And then we'd have great models to follow. Just like in ICWA, the standard of active efforts should be a gold standard for all kids and all families. So it shouldn't be that we fight against tribal innovations in this area. Rather, we should prop them up and then follow suit when those things work on behalf of all children everywhere.
Yeah, I'll note just that for a lot of tribes, they, and this is just to reiterate, they take termination of parental rights off the table. That's never an option. And so this temptation to, speed up the process so that this kid is more marketable for adoption, that's gone. There might not be placement with parents, but the idea that they are going to be legal strangers to their parents one day is never going to be the case.
I think it's my turn.
Mhm.
Yeah. Okay. So I want to just, I'm going to add a little bit here and then close quickly. So on this question about what can be done in the space created by ICWA. So working with tribal governments is just, it's really interesting just from the perspective of thinking about changing child welfare, because sovereignty and jurisdiction allow tribes a level of freedom to kind of redefine their laws. They don't have total freedom, as Lauren said, but a level of freedom that other groups don't have. So one of the central questions that was posed during the opening plenary was about what it would take to create a society where child welfare was unnecessary so that the system could be abolished because children and families had the support that they needed. And what I think we want to emphasize here is that Indigenous communities had those systems. They took care of children, and they took care of parents, and they helped families collectively in a system where government intervention wasn't necessary. And that didn't change until federal and later state governments manufactured the need for state intervention by first taking the children, turning the children who wanted to go home into delinquents who they could then keep away, and creating a generation of parents who had been traumatized and so severed from their cultures and communities that they didn't know how to parent within their cultures. So those systems were there, and what we see when we look at what tribes are doing today is, although it's sort of an uphill battle, many tribes have reintegrated some of the traditional ways that they understood that children should be cared for into their modern child welfare systems. And so there's a lot of examples of this, but I think it's important, I think, to note that so many of them are structural, right? So what we're not talking about is the kind of thin cultural competence version that you see in state courts. So this is not about making sure that Native kids get to be in contact with their communities and go to some ceremonies. These are interventions that sort of fundamentally restructure the relationship between the child, the parent, and the community. So customary adoption unsettles the idea that parenting is a zero-sum game. There's no reason why kids can only have two parents, why you have to terminate one of them in order to get another. That's just the thing that we've accepted in the Western system. So if you have an adoption system that allows a child to have unlimited parents, and you gain more, but you never lose them, you can redistribute children among people in a community according to who can best take care of them without them losing the contact and the relationship that they have with other people. It seems so revolutionary, but it's not something that we are able to do outside tribal systems at all. The other kind of what they call circle type processes, I've looked at healing to wellness courts in the delinquency context. So these are systems that kind of reimagine the idea of, say, discipline and treatment of children in a way that brings all the actors together and that isn't done in an adversarial setting, so that, again, it takes it fully, like, why are we offering services to children who need services only by getting them in trouble and bringing them into court and putting them in an adversarial setting? So we're reimagining the entire way that the system works. And the one that I think gets less attention that I've been particularly interested in is tribes' redefinitions of what the standard of best interest of the child means. So most tribal laws are still driven by that same standard, but they can be defined differently. And so often the best interest of the child is defined in terms of the child's individual rights and the child's sort of individual safety, food, access to education. And then what happens is, even in ICWA and even international standards where they try to acknowledge, say, for Native children, that relationship to the group is important, you still get this pitting of the child against the parents and the child against the group. So in the opposition to ICWA, what you hear is this idea that tribes' rights are somehow getting in the way of children's rights to safety. And so what you see is tribes redefining what a child's best interests are to understand, again, that the child, the parents, and the collective and the community are all related. So it's not just tribes need children and sometimes they sacrifice children's rights in order to keep the children. It's that the well-being and the continuation of the group is the same thing as the well-being and the continuation of the child. So if we don't define them in opposition, then we don't have the kind of system in which they're constantly battling against each other, and in which the parents are constantly battling against the collective to sort of hold on to their children. So it's those moments of redefinition that I think give us a way to see what a different system could look like. And the other thing I want to say to this audience is that I don't know, so for those of you who are interested in the way that those changes have made their way into like federal and state law, so for example, the work around kinship foster care payments and changes in adoption, a lot of that came from advocacy from tribes. So that they were using so many kinship placements that for a long time couldn't qualify as foster parents because they were legally different. And so a lot of what has actually changed outside of Indian country is partly a result of advocacy by tribal communities. So why is this the slide that I have up here? So this is a quote from the Chief Judge of the Yurok Tribal Court, just talking about how it is that at Yurok they have really tried to focus on their worldview and restructure how it is that their children are cared for in the delinquency and in the child welfare context. And yes, that is a picture of one of my kids. If you can't quite see the photo, the sweatshirt is from the Lac du Flambeau boarding school interpretive project. It's a photo of Ojibwe children at the Lac du Flambeau boarding school in Wisconsin that opened in 1895. And the band is restoring that in sort of an interpreted center. So I have this kid who has adopted this sweatshirt from me and wears it all the time. And so why am I showing you this picture? So two reasons. One is that I'm a non-Native parent of Native children, and so much of the resistance to the interventions of ICWA is by non-Native foster parents or adoptive parents who want Native children. And so I like to locate myself in this because I understand that if my children end up in the foster care system, they will go to Santa Clara Pueblo. There is a court that has jurisdiction over them, and there is a tribe that has a claim to them. And if you are a non-Native person who is trying to parent a Native child, you have to understand that. And so I like to push back against that. But the other reason is that I was getting ready for this panel yesterday, and this child, while wearing this sweatshirt, strangely, said to me, why doesn't anyone in Seattle recognize, do they know that I'm Native? I try to tell them, but do they not understand that I'm Native? And so I had to explain that many people don't recognize Native people as Native because they actually don't have an accessible visual category of Native people in the modern day in their heads. And this is, of course, because in the popular American imagination, real Native people disappeared sometime around 1900 when the boarding schools were supposed to erase them, or at least sometime around the 1950s when they were absorbed into white adoptive homes. So as a consequence today, a lot of non-Native Americans don't know what Native people today look like, so they don't see them because they don't realize that the people that they're looking at are Native, which renders Native people today invisible. And the problem of this modern day invisibility in turn then undergirds the resistance that you get from non-Native communities to tribal sovereignty, to jurisdiction, and to interventions like ICWA. So our purpose here has been to make visible the history of Native children in the child welfare system and related systems, and the leading role that Native nations have played in reshaping, dismantling, and restructuring these systems. We want to make sure that we're clear that child welfare emerges from settler colonialism, which is a system which had as its goal the erasure of Native people. And the system and the people who continue to challenge interventions like ICWA continue to be driven by this ideology. And with that, I think we'll close for questions.
Okay. Thank you so much, everybody. We have about 7 minutes, it looks like, for questions. And as I said before, we will remain in this space to have ongoing discussion for those who want to remain. If you choose, you can also have the option to select breakout rooms based on your geographical region, identity group, or discipline. We've gotten some good questions here, so I'm going to try in the short time that we have to stick with some of the bigger ones that I think you all might have something to say about. One is what are the roles, and this comes from Olivia Frank, what are the roles of large institutions like Columbia University in advocating and empowering Indigenous-led change in the welfare system? How can these institutions be helpful, and when should they get out of the way? I'm not sure who among you would like to take the first stab at that, but I think that's a good question for all of us.
I don't have a prepared answer for this, but something that comes to mind that harkens back to the discussion, I think, about the title of this session is the temptation to treat American Indian, Indigenous, Native American as this, small exception that it's like, oh yeah, and that instead it should be continuously folded in. And so, thinking about the funding, right? Tribes are always forgotten. And then it's this giant cluster of how to figure out how these laws apply to tribes. Resist that. Last summer, CNN, right, covering the election, all of these demographic outcomes, and then something else, right? Couldn't even remember what Native Americans were called, and so labeled it something else. Don't do that. Don't forget Indigenous people. Don't presume.
If I may, I think there's, on the one hand, there's obviously a lot of work that major academic institutions can do to support the innovations that tribes are pursuing. But I think we also have to be honest about the role that mainstream social work departments and mainstream social science departments often play in pathologizing the kinds of living conditions that we are kind of labeling child abuse and neglect and managing through this system. And I think a big piece of this is not only recognizing the way that institutions and what we're doing here today can support abolitionist goals, but to also recognize the way that the mainstream social sciences and mainstream social work ideologies and research buttress the kinds of systems that we're trying to break down.
So I related to that, I do want to point out, so there's every couple of months, basically over the last few years, there's been a new lawsuit challenged that directly seeks to overturn ICWA. So they're premised on different arguments. Many of them are constitutional arguments. And if related to what Frank is saying about pathologizing families, so if you look at those lawsuits, not one of them, so I periodically review them, I think that not one of them is premised the children in the story in which non-Native parents are seeking to get custody of kids in some way. None of them were removed for a reason that wouldn't have been fixed by a giant influx of aid and money to the child's family. So sometimes there's abuse, but it's like a mother needed to work and left the kid with somebody that they couldn't supervise. Every single one of those stories is a story that can be better addressed by an influx of resources into the child's community. I have yet to find one where it's a birth parent just sort of maliciously abusing their child. And that probably doesn't surprise most of you, but we're still doing this, this sort of definition of certain communities as terrible places for children.
Yeah, so, and this goes to one of the other questions that was raised. There's so many good questions here. So if folks want to stay, we can have a greater, longer discussion. But anyway, part of abolition, this is from Eric, part of abolition is talking about where we want the money to go instead of punitive systems. I hear the need for independent funding for tribal systems so that ICWA is not undermined by states. Others are calling for direct money to mothers as a key way to preventing child removal in the first place. If they can give tens of thousands of dollars to institutions and foster parents, why can't the mothers and the grannies and other primary caregivers, those who are doing the crucial work of protecting and raising their children, and in fact, the whole community's children, be paid for their work, first of all? And they'd like to hear your views on that.
So I'm sure everyone has views on this, but yes, so I never know who I'm talking to, so I'm not sure what the story is of everyone in the audience, but don't adopt a kid if there's a possibility that you can give their parents money instead, at sort of a baseline level. Thinking about, this happened in the wake of the earthquake in Haiti, and there's all these organizations trying to sort of pull kids out of Haiti and bring them here to save them. It should just, that should sort of be the first question on an individual level, just because a lot of the resistance to this comes from individual parents who feel an entitlement to sort of save children, or that they're doing something good by saving children. So that's one, but also on the paying of people. Yes, so paying people who raise children. Tribes are unique because it can come through a government. So not other groups in the United States don't have that governmental structure. The funding can go through a tribal government, and that's not as easy for other groups, but trying to put money into communities and then allowing communities to redistribute that money at the community level, to define what safety and childcare means at the community level, but also to pay the individuals. One of the most easy places that I see people not being paid is actually when a state system brings in someone so I see it in juvenile detention facilities. So they want to have someone who does sweat lodges for the Native children so that they have cultural practices. And the people that they bring are elders who don't have another job, who live hours away, who come and volunteer. So why are those people not being paid for those sorts of services. So at a very basic level, every time somebody is involved in doing this kind of care, they should be being paid for it, and the money should be coming from the other people that we are paying now.
All family placements get foster care payments easy. There's a separate push about how tribes should not have to jump through these state hoops for funding and should get direct self-governance funding, which is a whole bureaucratic mess, but seems really easy. But I think the flip side, I think it's hugely advantageous that tribes are governments, but they're also governments, right? And so they still need the same pressure and accountability and transparency as all other governments. Tribes are fallible. Tribes, even without the federal pressures, fall into traps that still require like dismantling and scrutiny. But I think that on a community level, that is a far more achievable goal than forcing tribes to fit the federal mold.
Real quick, I just want to add that I hope that throughout the papers and the panel today that we've emphasized not only our commitment to refunneling or funneling money directly to tribes and to tribal families and homes, but hopefully we've laid out a longer legacy to say that not only is that, step one, but this is step one of a much larger responsibility that we have as a nation to really take account for the violence, the continued violence that federal law and policy has intentionally sought in the lives of Native families and homes. So just trying to think about linking back quickly to the question about what can Columbia Law School do. I really love what all of my panelists said, and I just want to add that what Columbia Law School can do is also lobby Columbia and lobby other elite institutions to teach about these issues, as core to every aspect of your curriculum, not a one-off seminar on Indigenous Peoples Day to make you feel good, but to really think about how is our curriculum as a university, as an influential elite institution, how is our curriculum teaching these nuts and bolts about how we arrived at this moment? Because this moment is not just about our story as Indigenous peoples. These nuts and bolts are about our story as a nation, about all of the inequalities that we've heard about today and that we'll hear about tomorrow as well. So I just want to put that in there too.
Put one more piece in myself too. A lot of the problems that have resulted from these policies, starting with the boarding schools and then on to the adoption project and its progeny, they caused a lot of harms, and those harms, it's becoming more and more clear through social science research, can be addressed and are helped to be healed by basically helping tribes recover what was sought to be removed from them through those policies. In other words, language and cultural programs. So programs that retain and reestablish tribal languages and culture are huge. We did a publication, I'll put a link in the chat, that basically traced why the harms from the boarding school era even, or I'll call it the industrial school, which they were called at the time, why those matter still today. And then also starting to look at what does healing look like, because there is hope for the future. And so when you start to think about money to redress problems from the past, it gets a little scary, because just handing the money out to the survivors or the descendants of the survivors isn't going to do anything. But focused interventions, basically supporting community-driven healing programs, I think would be a great step. I'll put the link to the document in the chat.
Yeah, and just to agree with Brett, I mean, I really think so. Looking at Native communities is an interesting. It's an interesting way to think about what things might look like for other communities because of the existence of governments that are recognized. So when we have questions like, is it enough to kind of pay a little bit of money to all the individual people? We can think instead about a way to sort of identify a community and pay the money to a community and allow the community to sort of, that's the whole thing, is can a community restructure what it means to care for children, what it means to be safe, define that for itself, and sort of achieve that for itself. And because tribes are nations that are able to sort of directly receive funding and have authority over how they define their laws, they are able to do that in a way that it's not as obvious, but other communities can still do something similar. But we're not really allowed to think about groups under American law, except when it comes to tribes. And so it's a way to keep us thinking about community and group relationship to caring for children as opposed to just parents.
Okay, thank you. I noticed that it is now 20 after, so those of you who want to break out into other groups, please feel free. Those of you who want to stay, please stay. There are definitely more questions that could be answered. I'm happy to pose them for you. And we can also handle it in other ways, I suppose, depending on the size of the group that stays. But I think it's probably easier for me to put them out there than for me to look for a show of hands if we continue to have 150 some people in the room. But maybe while we're waiting, I want to ask this one question, which I think really touches on how to talk about these issues with people who maybe are not as keyed in as maybe some of the folks in this room. The question is, what would the panelists say to social workers, CPS workers in these states where Native children are disproportionately represented? And they say that this is not a race thing, but a class thing, that Native children are more likely to be at risk due to their lower socioeconomic status compared to white families, and therefore that this is not a racist disproportionality, it is a class economic issue. And I know that in many ways, everything you just said, all the history and all of that speaks to that, answers that question, but how do you in the moment when you're looking at that social worker, how do you in the moment respond to that type of argument?
Yeah, I don't think there's an elevator pitch that is ever going to effectively flip that. But I think yesterday in the keynote, there was a member from the Wabanaki Truth and Reconciliation Commission. And I think that is a great case study of the immense amount of work that is necessary for all communities to heal, because that's a wounded community, right? When you can't even see the history and the disparity that has taken place. And so I think Maine, and I think that tomorrow there's going to be a film screening of Dawnland, which I think it touches on the Wabanaki Truth and Reconciliation Commission. And so the answer is that it takes immense amount of grueling work that is uncomfortable and requires, actually acknowledging and interfacing with a very ugly truth that is true for every single corner of Turtle Island.
I have, I guess, a slightly different answer to that, which is, so again, and this is, I think, true for all children and families, but it is so obviously true when you look at Native families, which is the instinct of the Western systems, the carceral system and the child welfare system and the juvenile delinquency system, is to find a person who's creating a problem in some way and remove them, right? So if you have a problem in a family, maybe you remove the kid into foster care, or maybe you say, we're not going to remove the kid or punish the kid, but we're going to remove the parents. So if you look at the story of Native children, we know how that turns out. We tried that. That was what we did for Native children and for families for more than 100 years. That was the policy, and it made everything worse. So it is, as Lauren said, it's not easy to, I don't want to pretend that solving problems that happen in families where children are in danger or, people are abusive are easy things to do while keeping families intact and communities intact. It is difficult to do, but we have very clear evidence that the solution of pulling one part of that community and one part of that family out and putting it somewhere else, it is so clear that is not the thing to do for Native children. It is the thing that damaged communities for generations. So anything except for that is the intervention. So that just, sure, maybe there is a poverty problem and maybe families are struggling, but it can never be the answer to take the children away or even to take the parents away and lock them up.
And to the extent that poverty is an underlying cause that a social worker might think of as justifying removal, that's a fundamental problem across the board anyway. Poverty is not a reason for removal, and that's been made pretty clear across the board, despite the fact that it always is, right? And I think Teresa mentioned earlier that, we need to prioritize thinking about returning of lands. We need to think about the economic foundations that generate the kinds of conditions that we think of as being pathological, as being grounded in the settler colonial history of the United States, right? And to see that our institutions caused the conditions that we now individualize and pathologize in the way that Addie's mentioning, right, takes this really complex problem and then blames an individual family for poor outcome for an individual child, when that's the most obscenely, perverse way to think about addressing the problem. And I'd like to just kind of point out that, right, people have talked about 4E a lot, but we spend more on Title 4E foster care payments than we spend on cash transfers through TANF, right? So we spend more money paying other people to take care of other people's kids than we give to families and communities. And I think recognizing the material foundations in terms of dispossessed land and these kind of perverse funding mechanisms is really key to thinking about moving forward.
And what I'll add, that what Frank is laying out is, and what the question initially asked is not just, I think, what we would say to social workers, but what we say to students in our classrooms. What we all, in some context, teach these issues. We have to explain these things and have a pitch for our colleagues, for our disciplines who don't understand the work that we do and why we do it, because they see poverty. And I think that just keeping in mind that although the paper that Frank and I wrote and that many of the panelists wrote are all evidence driven, I think it's really important to remember that that isn't usually the way, at least that I start. I start by asking questions that lead to the sorts of conclusions and answers that Addie and Frank outlined. Well, why is there poverty there? What do you know about that? How did that come to be? Do you know anything about the legal history or the political or social history of those lands and peoples? And I think getting comfortable asking people to account for their biases through the form of questions is something that works really, really well for me, at least, as a professor and as a scholar. But leading with the evidence, I have found, and maybe you all think differently, but I have found leading with the evidence usually has a yeah, but that comes along that just wants more evidence and never really asks the person who's posing the question to take responsibility for the conditions that they're diagnosing. So just want to circle that back around.
Okay, thank you. What I want to do, because I know we don't really have time in 3 minutes to pose either of the other questions that are lingering here, is to just take a moment to acknowledge that your work in this field, all of you panelists, all of the work that you did and that you shared today has generated a lot of connections for people. And I'm seeing that in the remaining questions. And I just want to acknowledge the ways that they are connecting with folks so that folks can feel heard, and also that you can see the impact that your work is having. One is around the ways in which what has been described about the removal and loss of culture of Indian children, what the parallels are there for those who have been adopted intercountry, and how much that what you are saying also is being felt in the hearts and minds of people in those with that lived experience. The other is and Addie, I think this question arose while you were giving your discussion about the histories of the boarding schools and the assimilationist approach, and how we hammered things out of people, cultures out of people. And among that, some of that culture that was being hammered out for some people was that of the recognition of two-spirit folks, and of people who have a third gender, tribes that recognize third genders, and how what we lost, what those tribes lost when they were forced to become the girl in the boarding school, or the boy who learned the woodworking, or had to build the school, whatever. So I just wanted to let you all know that the stories that you were telling and the information that you were providing was received in a lot of different ways by the audience. And I want to thank you for that and for all of the work that you did. And I think now I have to tell you, you must go to the next session. So we're about to close this out, but it's been wonderful, and round of applause for our panelists and for all of you for contributing to the conversation. Thank you.
Thanks, everyone.
I see the panel still here. Are we sticking around for a sec to debrief?
I think we might have to get on a different Zoom to do that. I'm not sure how these rooms work.
Yeah. Do you want to send yours around, Teresa?
Yeah, sure.
Or we could make a breakout in here.
Who can make a breakout in here?
I got it.
They may not kick us out of here. Yeah, we can do a break.
Hi everybody, it's Mas. I just want to say I'm gonna close this room because we're gonna have to move on to the next one.
Okay.
But
So we
thank you
can't do a breakout room.
Yeah, yeah, not on this one. I'm sorry.
That's okay.
I'll email a link right now.
Okay, thank you very much. That was wonderful. It was a pleasure, being here with you guys. Thank you so much.
Thank you.
Thanks for helping us, Mas.
It's my pleasure. Thank you.